Well, good morning, everyone. Thanks for joining us. And good morning, Joe. You've put that in the chat. I can't find a way of replying to you, so morning to you and to everyone else that's joined. It's 9:31, so I think we'll make a start. For those that don't know us, I'm Ed Hussey, and also here this morning is Karen Gibb, Chris Miles, and Sandra Sue. And we are the Menzies HR Client Services team. So we help our clients navigate HR both from a compliance perspective and also when it comes to getting the best return on your investments in people. Compliance is our focus this morning, though, and every year there are some changes to employment law, but we don't normally make a song and dance about it because they're relatively technical. However, this year we have a raft of things that do require some awareness and in some cases some action by our clients. Hence today's webinar and another one next week. And there'll be more to follow later in the year for reasons that will become clear. And of course, if we get a Labour government later in the year, then we're probably going to be doing this next year as well. We are live today and we're recording the session, so it'll be available afterwards in our HR community and on our YouTube channel. We've received some questions in advance that we'll cover within the presentations, but we'll happily take more questions as we go through, so please use, hopefully everyone can see the Q&A button at the bottom or somewhere on their screen, depending on what kind of device they're using. Please pop questions in there. Sandra's going to be monitoring that and we'll take questions as we go through and at the end. And don't forget, we're always here for any follow-ups afterwards anyway, so feel free to contact us. Let's have a look. Oh, that's my welcome screen. Welcome. Let's have a quick look at the agenda. So first of all, we're going to have a quick overview of the changes, kind of all of them across the year very quickly, just to give you a flavour. But today we're focusing on family-related issues, so family leave and protections. We're going to go into those in a bit more detail today, and then we're going to do some of the holiday-related things in a bit more detail next week. As I said, questions as we go along, and then at the end. And finally, we've got a quick poll, which hopefully you'll help us with at the end, just to complete, to give us a feel for the issues that are most interesting or pertinent to you and anything that you would like a follow-up on. So that's our agenda. Let's get going. And first of all, Karen's going to give us a bit of an overview of all of these changes that are going on this year. So Karen, over to you.
Thanks, Ed. Good morning, everyone. Thanks for joining us live. It's great to be in direct touch and perhaps get some feedback on how you're feeling about some of these things. We do have a really busy year on the employment front, which is different. So I'll just tell you a little bit about the changes that are coming, and in particular the ones we're focusing on today. So we already have in place new legislation that allows us to simplify holiday pay calculations, and we've also had clarification on carryover rules for statutory leave. But because that's the topic of our next webinar, I'll save the details for then. It's going to be particularly relevant for you if you have employees who work variable hours, perhaps on 0 hours, or they're on part-year contracts, or if you have employees who earn regular overtime and commission and you're not yet factoring that into their holiday pay. That'll be of particular interest to you on the 1st of May. But today our focus is on new family leave entitlements and some changes to the way that the existing ones operate. So we're going to talk about changes to flexible working and the way that requests are made and dealt with. We're going to talk about the new carers leave entitlement. We're going to update you on how statutory paternity leave will operate and some better flexibility there. And we're going to talk about the extension to the pregnancy protection in redundancy situations. So they're the 4 topics for today. Later in the year, we're going to come back and talk to you in July. We've got some TUPE changes for smaller businesses. It simplifies the process for those with 50 or less employees. And then my opening line on the tipping legislation was the long-awaited tipping legislation. Well, now we're waiting even longer because we just found out that was meant to be the 1st of July and it's been delayed by another 3 months to the 1st of October. So we've already got some information ready on that, but we will come back and talk to you about that. But the date for that's now the 1st of October. Those of you in the hospitality sector will be very aware that this legislation will aim to ensure that all tips are paid to staff in the month following receipt. And you have to have a written policy on how you deal with your tips and how staff will receive them. So that's October. We know that is coming in. That's definitely in the legislation. It's the timing that's been delayed. The other two things we're waiting to see whether it passes through the legislation and then finally what that will look like around, we think, September, October this year. There will be potentially a new right to request predictable working hours for those that don't have them. So typically those on 0 hours contracts. And there will also be a new duty on employers to seek to prevent sexual harassment. So it's going to require employers to take reasonable steps to protect their employees. Those things are still to come. We'll talk about those later in the year. But I'll just pass back to Ed, because I know you also wanted to mention the immigration changes, Ed, before we go any further.
Yes, so there are also some pretty significant changes in the immigration space that have happened in February and April, as you can see there. So, and it's mainly to do with costs. So the immigration health charge, that should be not change, increased in February 2024. Fines for employing illegal workers have gone up by very large amounts, and the minimum salary requirement for skilled worker visas, which was trailed quite widely in the news a little while ago, has also come into being in April. So if you are a licensed sponsor organization, if you've got a sponsorship license, then those are particularly the health charge and the salary requirement are going to be important issues for you. And number two, really, for anybody, the plea is please make sure that you are doing your right to work checks properly as people join your organization. And if you've got any questions about that, then please do come to us. We help people from a practical point of view in terms of those right to work checks. We're not immigration specialists, but we do obviously pick up a lot of queries around that. And we do have contacts who can help with those things. So if you've got any issues around that, please do let us know. So we're going to move on and have a look at the first of those family-related issues. And the first one we're going to look at is a new right, which is to carers leave. So I'm going to start by giving you a little overview of that. So from now on, any employee an employee, by the way, I mean, for those that are interested, it's employees, not workers. So that is a bit of a distinction. An employee who has a dependent with long-term care needs is entitled to up to 1 week's unpaid carers leave in any 12-month period when they want to be absent from work to provide or arrange care. This is a day one right, so you have that right as soon as you join an organization, and it can be requested at any time during employment. So one question is, what's a week? And a week means the length of time that someone usually works over a 7-day period. So where, for example, you've got people doing varying hours, you basically need to look at what the average has been over the last 12 months or for whatever period it is that they've worked for you. To qualify for carers leave, the carer will have a dependent who either has a physical or mental illness or injury that means they're expected to need care for more than 3 months, or they have a disability as defined in the Equality Act, or they have care needs because of their old age. The dependent doesn't need to be a family member. It can be anyone who relies on them for care, essentially. The leave can be taken in one continuous block or on separate days, but there's a minimum half day that you can take at a time. And so that's a new entitlement that people have. Let's just turn to Sandra. Sandra, did we get any questions on this one in advance?
Yes, we did. Good morning, everyone, and thank you to those who had pre-submitted questions. So we've handpicked a few per topic and just to share throughout the session. But again, feel free to pop any questions that you have in the Q&A section. So Ed, the first question that we have is, how much notice does an employee have to give for carers leave?
Right, so yes, there is a notification requirement, and so if the request is for half a day or a day, the notice period is at least 3 days. If the request is for more than 1 day, the notice period must be at least twice as long as the requested leave. So in other words, a request for 2 days needs 4 days notice, a request for 3 days needs 6 days notice, and so on. Just related to that, there are very limited circumstances in which an employer can postpone the leave requested. And that is only if the absence is going to, as the ACAS guide says, cause serious disruption to the business. And you are obliged to give another date or dates for that carer's leave within a month. Now, obviously, in a circumstance where someone needs carer's leave, it's going to be pretty hard for that person to move it. So I don't expect that that will be something employers are doing willy-nilly, and that it is very limited in their ability to do so.
Perfect. So the next question is, does an employee need to provide medical or other evidence for the dependent?
No, they don't. So this operates effectively on trust. The employer can't require the employee to supply evidence to demonstrate that they have this caring responsibility.
Thank you. And the next question is, what if the request is urgent?
Well, if it's urgent, obviously you've got those notice requirements. So if something urgent crops up, I mean, hopefully in most cases, a pragmatic solution would be found anyway between the employer and the employee. But from a legal perspective, there is dependence leave, which is a separately type of entitlement, which has been around for a long time. And that basically says for a dependent, if there is a kind of an emergency, then you're entitled to a reasonable amount of unpaid time off in order to resolve that particular issue, either by finding someone to look after a sick child or something, or to otherwise resolve the problem.
Perfect, thank you. And we have had a question come in through Q&A, which kind of relates to our next question, which is, can you just clarify if the leave is unpaid?
Yes, the leave is unpaid. Well, the entitlement is to unpaid leave. Employers might decide to grant pay, and that is entirely up to them. What's recommended, obviously, is to have a policy on it, because what you shouldn't do is make it up as you go along. So if one person's applied for carers leave, you pay them and then you don't pay the next one. It's important to be consistent. So have a policy as to how you're going to approach that, be it paid or unpaid, but set it out in writing. And that's the best way to go forward.
Perfect. There are no further questions at the moment.
Okay, I did see one pop up saying, would there be a copy of the slides available? Yep, I think we can do that afterwards, so no problem there. I think that might have been in the chat. Yes, that was in the chat. Okay, let's move on to our next change, which is around the rules for flexible working, which I'm sure everyone has been quite familiar with over the last few years of that entitlement. Well, there are some changes afoot, and Chris is going to take us through those.
Thanks, Ed. Morning, everybody. Can I have the next slide, please, Ed? Thank you. Morning, everyone. Yes, so I mean, the right to request flexible working has been around for a while now. I'm sure you're all aware of that. But the focus of these changes is essentially to make it easier for employees to apply, and they're also tightening up on the employer's responsibilities to respond fairly, to respond in a timely manner. So that's kind of what these changes are bringing into line. So you'll see on the slide, the first change is it's now a day one right. So previously you had to have 26 weeks service to apply for a flexible working request, to make a flexible working request, and it's now a day one right. The second change to the detail is the employee can now make 2 requests in any 12-month period. Previously it was 1 a year effectively, so now that's increased. There's also no longer a requirement for the employee to state their case. So previously employees, as part of their request, would be required to set out how their change in working hours might affect the business, and how the business might mitigate the disruption caused by any change. That's no longer a requirement. They just need to request the flexible working. It's down to the business to decide, you know, what the interruptions will be and how they might manage that. The employers also must consult on alternatives. So you can't just say yes, turn down a request point blank. You need to have a conversation with the employee and potentially discuss alternatives or, you know, compromise. I mean, a lot of employers would have been doing this anyway, because if someone makes a flexible working request, you're going to have a conversation with them. But this just, again, tightens up those regulations. And the other big change is that the employer now only has 2 months to deal with the request, whereas previously it was 3 months. This is probably going to be the most challenging part, because it's going to mean that, as well as potentially facing an increased number of changes, the employer's got to deal with them far more quickly. And so, you know, that will present challenges in itself. So that's a very brief summary, not a huge amount of changes, but some that definitely you need to be aware of, and definitely need to keep in mind if somebody should make a flexible working request to you. So Sandra, have we had any questions on this one in advance?
Yes. So Chris, are there any specific grounds for declining a request that the employer should use?
Right, that's a really good question. And actually something that's already in the legislation as for flexible working, there are specific grounds that the employer must use. We have a pre-prepared slide, excellent. And so you'll see them all on the screen. I'm just going to dip into a couple of them, because just for point of interest. So extra costs that will damage the business, for example. So if in meeting the employee's flexible working request, the business would incur such large costs that it would damage the business, that's a valid reason for turning down a flexible working request. And the other two that I'll just dip into are the business will not, number 6 and 7, the business will not be able to meet customer demand, or there's a lack of work to do during the proposed working times. So an example here would potentially be if you employ somebody to work through the afternoon into the evening, because the clients they're dealing with are based in the States, for example, and they put a flexible working request in, so they'd actually like to start work at 7 o'clock in the morning UK time and finish mid-afternoon. Obviously the work wouldn't be available, and you wouldn't be able to meet customer demand by changing those hours. So that's a valid reason for turning down a request. Anything else, Sandra?
Yes. Does the 2-month time period include any trial to see if it's successful?
Right. So yes, good question. And I mean, we do always recommend a trial period when you're trying to put in place when a flexible working request is implemented. Now, the legislation says, and I'm going to read this, employers must make a decision within 2 months of the request or longer if agreed with the employee. So that's the key part, is actually you can have a conversation with the employee and decide and agree what that flexible working arrangement will look like within the 2 months. And provided you get, and you communicate that in writing to them, but provided you get their agreement to then put in place a trial period, that can follow on. So your decision is made and communicated in writing within 2 months, allowing an appeal as well, which is also best practice. And then you can agree a trial period to follow that to make sure it's working. But the important thing is to have made sure you've communicated the decision within the 2 month time frame.
Perfect, thanks, Chris. We've had a couple of questions come through.
Mm-hmm.
So the first one is, does the 2 month rule mean that we have to reduce this trial to 2 months? I think you just answered that one.
Yeah, you can have a trial period, but you can have it following on from your decision making. Yeah, that's 2 separate pieces.
Perfect. And then the next question is, am I right that this is about the right to request flexible working rather than the right to flexible work itself?
Absolutely, yes. It's a It is a entitlement to request flexible working. They're not entitled to the flexible working. They're entitled to make a request, and all the things we've just talked about you need to cover, making sure that you have a conversation with the employee, that you discuss alternatives, and if you do have to turn it down, you turn it down based on one of the reasons listed on the screen.
Perfect, thanks, Chris. There are no further questions.
Okay, thank you. I think Ed's going to take back
Well,
over now for the next section.
Thanks, Chris. Yep, before we move on to paternity leave, we wanted to say something today about a protection that is changing for pregnancy and maternity returners, although it's a bit wider than that. But Karen is going to explain, fortunately.
Thanks, Ed.
Over to you, Karen.
So those of you who have dealt with redundancy situations may have already come across the protection in place for employees who are on maternity leave. That protection's been there for some time, and employees on maternity leave were provided with additional protection from redundancy by being given priority for any alternative roles in the business. So they essentially went to the top of the list for any other job that was available. This was in an effort to reduce the huge number of job losses that occur for women when they take time away. And I think the view is that unfortunately that protection hasn't made any substantial impact, and that maternity and other extended types of family leave are still an extremely vulnerable time for job loss. So this protection has been extended. It begins at the point that the employer is informed that the employee is pregnant, and the protection ends 18 months from the date that baby is born. The protection applies in a similar way to those going through an adoption process, starting on the date of the adoption placement and also lasting for 18 months. And in a slightly different way, it applies to those who take an extended period of shared parental leave. That has to be for more than 6 weeks. And then they will qualify for the 18-month protection from the birth or adoption date again. So essentially, the protection is that during that time, the employer must, in a redundancy situation where there is a suitable alternative, that protected individual will have priority for that role. And that's really something to take into account whenever you are going through a selection process for redundancy and coming out the other side and looking for alternatives for those that are at risk. So I can very quickly also carry on and finish off with the paternity leave change. That's all eminently sensible, kind of makes you wonder why it took so long, and it's extremely simple. So instead of only taking paternity leave in the first 8 weeks after the baby's arrival, it can now be taken for the 52 weeks after the baby's arrival. That's either birth or adoption. And instead of having to kind of make your choice, do I want 2 weeks now or only one, and then you would lose the other one, you can take the 2 weeks at different times. So one week at one time, 1 week or another, or the 2 weeks all at once, at any time in those 52 weeks after the baby arrives. So I think that's all lovely and simple. The only thing I would caution is that when you read some of the policy statements, and that includes the policy that we're drafting for you, our clients, the actual rules around applying seem to have been made very complicated. And I think that's because babies don't arrive on time. So the kind of rules around people applying for paternity and needing to change the dates, if I'm honest, they look overly cumbersome to me. So, you know, I'm sure that employers and employees can have a reasonable conversation about some flexibility as to when their baby's going to arrive and move the dates accordingly. But I just find the policy wordings are a bit clunky. We'll make that as simple as we can. So yeah, very straightforward change. Sandra, anything anybody wanted to know there?
Yes. One question is, can the leave be taken in single days, or does it have to be complete weeks?
Yeah, we've talked about a couple of things today. Remembering what Ed said, the carer leave, it can be taken in single days. In fact, it can be taken in a half day if they want to. So that's single days. But the paternity leave is still a week. So that doesn't chunk down into the equivalent of 10 days. It's still only a week at a time for them.
Perfect. Thanks, Karen. We've had a question come through. Are there any changes to paternity pay, or is it only the leave?
It's only the leave. Paternity pay, there is paternity pay, so it's not an unpaid entitlement, but it is only paid at the statutory rate. That's very low, and you are very welcome to enhance that in any way that you would like to for your employees taking this leave. And once again, similar recommendation to the carer leave. Any enhancement, we'd recommend you put in a policy and that you then apply that consistently.
Perfect. Thanks, Karen. There aren't any more questions at the moment.
Okay. All right. Well, in our next section, we're going to take any live questions. So I'd encourage those of you listening to pop your questions into the Q&A or into the chat so Sandra can pick them up for us. And while you do that, I just wanted to mention another thought that I had and discuss that with Chris for a minute. These new and extended entitlements and the additional flexibility around it, it strikes me that that's going to put a real emphasis on your record keeping. So you're going to have to account for split periods of leave. As Sandra's just asked me, you know, is that individual days? Well, for the carers leave, yes. So you're going to have to be able to track that. And I wonder, you know, with that emphasis on accuracy and record keeping, Chris, do you want to make a comment on how an HR system can help with that?
Yeah, absolutely. Yeah, it's a really good point, Karen. You know, we always recommend capturing employee data and a good HR system for security, for ease of access, for all the reasons that we know about. But most HR systems also include a leave planner, and it means that employees can apply and track. Employers can approve, and all leave can be tracked via an HR system. This includes holiday, maternity, paternity, emergency leave for dependents, parental leave, and carers leave as well. So a system makes it easier to track, more accurate, and it means the employees can see what they've taken as well. So they can see their own balances and leave taken under any particular leave type. So yeah, an HR system incorporates a planner is a really good tool, especially with these changes going forward. Yeah,
absolutely. Okay, thanks, Chris. I knew you'd want to make a comment on that, so thank you.
Thanks.
Ed, I think we're taking questions now, aren't we?
Yeah, so let's see if there's any other questions that have come in that we can answer, and then we'll have a quick look at the poll. So, Sandra,
Yep.
have we got anything?
Got quite a few questions coming through now.
Okay.
There's a question from Victoria. Do you foresee any changes to parental leave?
Shall I quickly say that?
Yes,
So
do.
there's an existing entitlement for employees to take 4 weeks of parental leave. We haven't seen any commentary really around that. And I think with the focus on these entitlements being introduced, all in a bit of a flurry, to be honest, I haven't seen any commentary on increasing the parental leave entitlement. No, we don't see any other leave in that area coming forward on the agenda this year, certainly.
Yeah, I agree. I think it'll be interesting to see what happens if we do get a Labour government, and what happens to things like parental leave going forward.
Yeah, and these things are unpaid, so you know we're really talking about you know it's quite difficult, and most parents will look to take that only when they have to, and ideally they'll perhaps look to their employer to offer something more generous that allows them to have some earnings at the same time. So it's quite a tricky thing for them, I think.
Perfect, thank you. The next question is, can you confirm if any proof of dependency is required when approving carers leave?
No, there is no evidence requirement around carers leave. So it will operate on trust. I think if you suspect at some point that there is some abuse of it going on, I think that would be a moment to talk to us really, or your HR advisor, about what you might be able to do about that. But until that point, no, there's no evidence base. So I think it's just a question of you know, knowing your employees and their circumstances as best as you can.
Perfect, thank you. Another question: if someone takes 1 week of paternity leave and then moves to a different company, would we need to tell the new company that they already had 1 week of their paternity leave?
We actually talked about this, didn't we?
This is a great question.
Yeah, it's a great question. We talked about this when we were talking about capturing leave, because actually it's always been the case that take parental leave. Somebody asked about parental leave earlier. So that actually is an entitlement that we've never known anybody ask for the data when people have gone from one firm, one business to the next. But actually it does carry on. So if you've had 2 weeks of your entitlement and you change jobs halfway through, you've actually only got the other 2 weeks left, and that can go with you. But nobody ever asks, not as far as, well, not in our experience or in our managing of employee data. So I think it's just something that gets lost. But actually, yes, it does transfer over. Now, because paternity has a statutory payment to it, I guess that might transfer over. But the only thing that strikes me that I haven't looked at is you do have a qualifying entitlement to paternity with your current employer. So I don't know that you can necessarily qualify with the other one. I mean, you've got 52 weeks. So, I mean, I suppose you might, but that sounds to me pretty tight to qualify for one and then qualify for the other. You'd be taking the leave right at each end of those 52 weeks. So I can't really see that one carrying over. We think that the things that are a day one right, so carers leave and the others, then yes, I think there is the potential that would carry to another employer.
I think that's really important for record keeping as well. That's, sorry to jump in there, but that goes back to what I was saying about recording it on an HR system, is actually if you've got a record somewhere, if you do ever get asked, you can provide that information.
Yeah.
Perfect. So just as a follow-on from that, we've had a question. So as an employer, can we ask the candidate if they have taken paternity, flexible, carer, parental or shared parental leave when we onboard them in the guise of keeping records?
Shall I have a go at that one? I
Go
think
on
that
then.
I think the key to that is when you onboard them, not before you've hired them.
Yeah.
Because if you make a judgment about someone in terms of a decision to employ them based on whether they've availed themselves of their statutory leaves, you could have a slight discrimination issue there, because you're going to be discriminating against them on the basis, potentially on the basis of, you know, of having been on, you know, maternity leave. I mean, you know, so I wouldn't do it as part of the decision-making process, but I don't see that there's an issue doing it in the data gathering process when someone is actually joining you. It's a good question.
Yeah, I'm not really sure. I guess I don't know. I suppose, seeing as we've said the entitlement can carry from one to the other, that might be relevant. But we are talking unpaid entitlements here. So I suppose the simple answer is yes, but my other sort of rather more complicated answer is how are you going to frame that in a really positive way? And what are you going to do with the data? Because you're going to load that onto your system with a start date. And then how are you going to load historic data? And you certainly don't want to be carrying over, you don't want to be asking issues around and trying to capture issues around absence in the past and then load it into your system. I'm just not entirely sure. It's not something I can say I don't think we've ever looked into.
It's never
But
come up in an operational sense, I don't think. But I think what we
Yeah.
might do is give that a little bit more thought, and when we send the slides out, maybe to the people who've joined us today, maybe make an additional comment on that,
Yeah,
on
it's
that
very
question
interesting
when it
point.
goes out. So we'll have a
Mhm.
slightly closer look and give you a more considered view when we send the slides.
Yeah.
Perfect. Another question is, if the employer agrees to enhanced paternity pay, does the employee still get statutory paternity pay?
I can answer that. The one is inclusive of the other. So when you make a payment for full pay, the statutory entitlement is included within that. So you don't pay both.
Or even if it was part pay, even not full pay, even if you paid, you know, £100 more than the entitlement, it would still include the
inclusive.
statutory entitlement.
Yeah.
Topping up effectively, isn't it?
Topping up. There you go. That's it.
Yeah.
Okay. Are we there on the questions?
Yep,
What?
all.
So while people have a think about whether they've got any more questions, and before we just finish off with a couple of other bits of information, let's just put the poll up if we can. So just take a couple of seconds to look at this and just tell us whether there's anything you'd like to know more about, if there was more detail you want to go into, or if there's any, or if you just think it's a priority for you that you'd like to hear more from us on. So everyone can see that, just tick as many as you want to prioritize. Okay. So I don't think we've got any more questions, have we, Sandra?
No more have come through.
Oh, so let's then just talk about our next webinar. So a week today, same time, same place, we're going to cover the holiday change aspects of these legal updates. Particularly important for anyone who employs variable hours workers. There's quite a bit around that. So please join us, those who haven't already registered, next Wednesday. And please also, if you haven't already, join our employers community. There's a QR code there, point your phone at it and and join us. It's free, and it's where we post all of our content. It's where we have different sections for different aspects of HR work, with articles and useful information and chats and past events that we've run that you can see recordings of, little snippets of information that give you a summary of some of the key questions that we get asked in HR. So please do join us on that platform. So I think it only remains for us to thank everyone for coming. It's been lovely to have you along this morning, especially some old friends that have popped up. So we'll be catching up with you afterwards. And yeah, you know where we are if you need any follow-up. And hopefully we will see you again next week.